flight mode. Center for Postgraduate Studies was set up by the Honorable Vice Chancellor for the supervision of the LLM degree and to organize events for the students in addition to their regular coursework. In today's session, our speakers shall be introducing us to the concept of digital forensics in litigation and investigation, the important use of forensic tools and technical knowledge of e-discovery for lawyers, cybercrimes, personal experiences in the field, and the career path ahead. Having said that, on behalf of the Center, I welcome our honorable guests, Ms. Samara Sequeira, partner at Khitan & Company in the dispute resolution practice, and Mr. Keval Seth, founder and director of Convert Zeus, a consulting firm. Ms. Tamara has an experience of almost 10 years in civil and commercial litigation. She has diverse experience in advising multiple clients like multinational banks and domestic corporation, individuals and firms. She has advised clients like HSBC, Toyota, Rolls-Royce, Enel Energy, a wing of Government of Netherlands, and Hardcastle Restaurants, among others. Mr. Seth is a risk forensics and dispute advisory professional with 13 plus years of experience. His areas of expertise include forensic accounting and economic damages, expert witnesses, investigations, and risk advisory. He has worked with clients in several countries like India, United Kingdom, Australia, Singapore, and Europe. In the investigation sector, he has led multiple banking and corporate investigations in many banking frauds, including the ICICI and PNB scams. If the presentation is set, I now request the panelists to commence the discussion. The format of the discussion is interactive and the students can raise their queries at any time during the discussion. Please try to keep your questions brief due to the paucity of time.
conduct a digital forensic on the systems here. Is this working?
Yeah, now it is. Good morning. Good morning. Good morning. Thank you. Some tea, coffee. I heard you had some lectures before this. So, while we all are here, anyone wants to take a shot on why this topic is important? What all do we want to cover? What all do we want to hear or discuss today? It's a very small span of time, 1.5 hours, but still we'll try and cover maximum that is relevant. Anyone wants to take a shot?
In order to protect our data, first of all, and then make accountable to those who are utilizing it in any other forms. Like data is utilized by other people, those who are not having the access, those who should not have the access. So we are having this digital forensic team so that we can analyze who is the culprit and we can bring them into justice.
Good attempt. Please.
Sir, in general, in other criminal laws or the laws related against the human body or the property, there are very descriptive laws how to conduct investigation in those particular matters. But when it comes to the cyber crimes, so there are not very vast or very descriptive laws that how to particularly conduct investigation, how to examine evidence, and that's all. So therefore, this topic that is digital forensics is very necessary. How to know that how should we conduct investigation, how should we analyze the particular evidences to reach up to a conclusion and decide a particular case.
Nice one. I think you hit the nail on one of the topics that is not yet thought of by people. There is certain standards set by ISO, but apart from that there is no international standards available to do a digital forensic, right? So that's something that people are looking at how to do and what to do. Obviously there are laws covering on, every country has their own set of laws. We have some evidence act, and maybe Tamara is the right person to speak about that. But I think you guys covered, you touched upon certain important aspects. Now why this topic is important, because you take any investigation, you take any crime, you take any disputes for that matter, there's certain set of evidences which are not, hard evidences on hard paper, no more, right? There are times when you had physical copies available everywhere. Now is the age where you have everything, every damn thing on digital setup, right? So it can be emails, it can be hard disk, it can be your chats, it can be your messages, everything. So that is why this becomes very, very important topic to cover, to say how can you unearth what you don't know of. How can you protect, as you said? There is certain way of unearthing that evidence, presenting it, and then making use of it. So that is why this topic becomes very important. If you go to Wikipedia, it simply says, digital forensics is a branch of forensic science encompassing the recovery, investigation, examination, and analysis of material found in digital devices, often in relation to mobile devices and computer crime. Now, they may not have gone one step ahead to say that this is also important from a point of view where you have to present in the court. So the form, the nature, in how it has to be presented, what all precautions have to be taken, what all procedures, what tools and technology have to be, adapted to do that, is certainly not covered by Wikipedia, obviously. But we know for sure, because we have to, rely on that. The court is not going to rely on any hanky-panky stuff. Going to a court and telling them that, look, we found this evidence, we found this XYZ method. They are going to rely on a set of procedures which are very, very robust and which are accredited. I wouldn't say accredited, but which are credible enough to rely upon, right? So that's the whole idea. So digital forensic is not only the technical part on how you do it, but it also encompasses a lot of procedural aspects on, the precautions that you need to take on how to do it.
was so much more that needed to be taken into account. There was an understanding of, even if we take a printout, can a printout be tampered with? Can a computer resource itself be tampered with? And it's only maybe in the mid 2000s that people began to realize that code can be tampered with. It's not something that used to happen earlier. And with the change in what exactly was happening with the use of computers and how people were using computers, digital forensics became that much more important, because what you can do on a computer also means what you can remove from a computer. So, so digital forensics gave us the understanding that it's not just about changing something, but deletion can also mean a huge change to the data that you retain, the data that you put forth, and therefore it became important to understand how courts need to view the deletion of data itself. Very recently, and I'm actually still working on it, is a matter in which we are trying to establish that information has been deleted. We have only so far, through a digital analysis, been able to understand that a chunk of material has been deleted, but we're unable to understand at this point what has been deleted. So now the test for every litigation is, what is your loss? Everyone is only looking for what is your loss, what are you looking to compensate yourself for. So sometimes when you have a data deletion, you don't know what you are asking for compensation for. And that's where a digital or a forensic analysis looks into deleted data as well. So even a formatted laptop, digital forensics allows you to go back and see what has been deleted, what has been packed up, what has been removed. And I think that's something that Keval is doing on a regular basis, and he is then able to sit as an expert witness before a tribunal, before a court, and explain what has been deleted, which is something that on simple terms you and I may understand that, or even a lay person, even as a lawyer, would understand that something has been deleted. But what is the effect of that deletion is what digital forensics is all about. So when we talk about cyber crimes, we're talking about a series of, it can be deletion of data, it can be changing of the nature of data, it can be changing of source code. And say now with WhatsApp and Telegram, which are essentially your chats are supposed to be completely private. So you reach a situation in which you want to know what those chats are, because essentially there can be and this is something that we're seeing very often with employees, and this is actually I don't know how much whether Keval will agree, but from a litigation perspective, our most important use of digital forensics these days is ascertaining employees stealing information, confidential information of companies. And that is the reason why now a lot of companies, and including law firms, you can't share any data on WhatsApp. So no PDFs, no Word documents, because of the end-to-end encryption. Otherwise, there is no way of ascertaining what is the data that has been exchanged on WhatsApp conversations. And prior to maybe a couple of months ago, when this became more important, everyone was sharing data on WhatsApp chats, Telegram chats, conversations, and the amount of confidential information that was being taken out of companies. And then you sort of start a new company for which you don't have to put in the R&D. That's essentially the largest problem with theft of confidential information. And in recent times, we've seen the use of the IT Act, of the Evidence Act, to have digital forensics, the big four, coming in, looking into computers and seeing what has been transferred via WhatsApp, what has been transferred via Telegram, and what information is actually being removed. And in recent times, under the IT Act, they have now found that even that removal of the data, whether you use the data or not, the removal of the data itself is a crime. And that is where digital forensics helps us to ascertain what has been removed, so that we can ascertain that a crime has been committed. And that is the most important aspect of digital forensics in litigation. We'll do a few more case studies and explain how the provisions, the simple provisions of the law, are being used from time to time, and how digital forensics ties in with that, and how courts view it, how arbitral tribunals view it, and how it can be used in the future.
Tamara rightly said, there are few essentials or objectives on why digital forensic is important. Now the first, responder procedure. So the moment you see, or a complaint or a suspicion from, let's say, management of the company, or someone has, blown a whistle, what do? I mean, do you allow people to tamper with the evidence? Do you allow people to tamper with the information, data, whatever they're seeing? So that's where the speed at which a company or an organization reacts to something that they find suspicious of is where it becomes very critical. Because if you allow people to then play around with that set of data, play around with, let's say, audit trails or logs, or who has access to those files, that is where it becomes very, very important. You bring in the right set of people, you do the digital analysis and get over with it, because otherwise the first set of data that is available to you is gonna go missing. So that's the first objective. The second, not corrupted. Obviously, whatever data you pull out, you extract, has to be in its original form. It cannot be corrupted at all. Otherwise, leave aside the presentable in the court of law and all, but even for your analysis, it is not going to be easy for you, because people would have then tampered with it. So that's very important. Data acquisition and duplication, on how do you do it. That's a procedural part. We'll talk about it in the coming slides. Recovering deleted files. Now, as Samara said, there's a lot of tools and technology nowadays available where you can almost recover everything. Almost, I would say, because, so let's say, for example, I'm not giving you ideas, but so there's a certain difference in way the laptops and other digital devices are built up. For example, just a recent case that I was on, I had to send one team member from Bombay to Bangalore on a day's notice. Now when we reached there, good that my team member got in all the tools that we had for all kinds of devices. The device turned out to be a Mac laptop. Now in Mac laptop, what happens is, the moment you set up to a factory setting, you go back to a factory setting, everything is wiped off. Other laptops, you would still have traces. You have some other point of view?
Yes, sir, because even if we'll go to phone and we will do TWRP recovery.
Not phone, this is laptop.
Yeah.
Laptop, there are no trails. There is a trims mechanism that happens in Mac devices. So laptops, if you go to factory settings on that device, no forensic tool is going to fetch you the data. So that aside, there are certain times when you have to crack also the passwords of the devices. So here everything is important, where you have to recover certain deleted files. Now the data that is there present in the system is any which way is harmless to the person, so they have kept it as it is. They have deleted the data which is going to harm them, right? So that is where it becomes very critical to recover most of the data. So other devices are relatively easier than Mac, I would say. So hence the fourth point, recovering the right set of data is again important. Analyzing digital media to preserve evidence. Now you have a lot of tools and technology to analyze the data in the manner you want. Now based on the suspicion or the allegation or whatever the case is, you would want to then use certain tools and technology. Sometimes it can be a simple Excel thing that can work for you. Sometimes it can be a Tableau thing. There are many tools and technology. There is a list that I'll show you. To analyze in a particular way not only is important for getting the right information, but also saving a lot of time. Now people like Tamara and all, they are constantly under pressure to make happen the cases from the clients. So they would rely on people like us to make it as quickly as possible. So at that time, if you happen to use a wrong tool or an incorrect one, that is where you waste a lot of time. Sometimes we've seen manual things working well than a tool, because there is a certain human element to it. On the way you would have written certain emails, or you would have made a chat message look like it. So picking up the right device tool is very important.
So what's the margin of error while analyzing such digital media?
Margin of error in terms of accuracy or in terms of comprehensiveness?
In both ways, because when you will go to dispute, then this point
So margin of error, every tool in technology would have certain methods of doing it. Let's say for example, if there is a tool which gives you artifacts, there is another tool which does not give you artifacts. So the tool that does not give you artifacts or trails or picture images, they would qualify that in the report. So when I give a report, it is not only investigation report, but there is a triage report to it, which comes in with the tool and technology. So I would say, okay, I've used this particular tool. This particular tool, I know for sure this has a con to it. It cannot perform so and so analysis, or it cannot recover so and so data. That is why that is where I need to qualify. Because if tomorrow I or my team member are going to stand in the court of law to tell them that we have done this, so the judge is going to ask me, right, as you said, what is the accuracy level, what is the comprehensiveness. So again, comprehensiveness at the time of recovering and then analyzing. So analyzing, again you have certain leeway because you would do a keyword search, we'll come to that also, or we do a sample base. We can't, you will have, let's say for example, you've run the company for let's say 10 years, every year you would have 20,000, 30,000 emails. Your emails would run into lakhs. I'm not going to sit and review each and every email, nor someone like Tamara is going to expect me or my team member to do that. But the point is, if I have told the court that these are the things that we found out, there can be additional things also. But if I am able to prove a suspicion or an allegation through what I have already found out, it makes up the case for them any which ways, right? Then the important part is the forensic report. Like I said, it's not only about what have you unearthed, it's also about the procedural aspect. So the forensic report has to be comprehensive enough to say that, what steps have you performed, what precautions have you taken, what tools and technology you have taken, what are your own skill set and qualification to do this in the first place. Chain of custody. Now we'll talk about that. Tamara will explain a lot more in detail about chain of custody. One of the most significant aspects of the entire digital forensic. It not only places responsibility on the organization or the client, but also on someone like us to maintain the chain of custody. Like for example, if you were the client and you would have told me, look Keval, this is a laptop of XYZ employee of my company, I read a subscription, we have fired him or we have sent him on leave or whatever, we need you to digitally examine this. So I would do that, but I would require a certain chain of custody to be maintained on how, when, where, who's given me, how did I receive the entire digital device, how did I examine, what were the tools and technology, who all touched or actually accessed the laptop before it was digitally examined, after it was done, the entire chain until the report. So the chain of custody becomes very, very important to maintain and then to tell the court that look, we've taken enough precautions to do this. And then obviously, the results have to stand on their own in the court of law. And then someone like us would be called upon to testify as an expert witness on how we've done, what we've done, and so on and so forth. Now one may, always talk about investigations and disputes being the forefront of digital forensics. There are certain usages that, these are just some of them maybe. Intellectual property theft, like, Tamara just mentioned in her brief, very, very critical in today's world because a lot of data gets vanished. Imagine someone like huge giant like an FMCG client, right? HUL, you take Nestle, you take anyone. Now the supply chain would be the most critical part for them, how they have their supply chain maintained, the distributors, the retailers, everywhere. If someone takes away that data and goes on, you've gone, company is gone. Or if someone takes away the margin data, gone. Now a compete for FMCG, HUL will be someone like, let's say for example Nestle or Marico or whosoever in that product line. If they get the data of retailers, distributors with the margins, they would just go to the market and do all the cleanup that they want. So very, very important again, industrial espionage, employment disputes, fraud investigations, we know, forgeries, a lot of forgeries. Important case again with leading firms, Calcutta based. I mean, they forged the signatures of a big 4 accounting firm, which got unearthed only after a year when the French people got to them. They said, where's the annual, balance sheet and all. So they said, we are yet to do that because we have not been presented with the data. The CFO, the global CFO, tells the Indian accounting firm that we've already received your balance sheet and annual accounts. He said, who signed it? Forget who signed it, who audited it. We have not even started because your company in India is not ready with the data for us. And then you realize that not only were the documents passed on to the France office, but also uploaded on MCA site. And then we were called. So if you happen to notice, if you put a signature, okay, you copy the signature and then you paste it and then you convert that into a PDF. When you click on that, there is a certain box that gets created, right? So you can make out of a PDF. If that signature is actually and then scanned, or you put a signature on a Word document and then created a PDF out of it. So it was very easy, very naive for people to do that in the first place. They would have actually tried that where they any which ways tried bigger things. Then you have bankruptcy investigations nowadays, sexual harassment. Okay, let me ask you, any wide guess on how digital forensic would have help sexual harassment cases or investigations? Anyone?
Tracking the source.
Sorry?
Tracking the source of the publishing this. Even if the harassment is published, we can track the source of it and ultimately the correct.
Okay, so let's say an allegation is made towards an employee of XYZ company and we were to investigate a particular case. Now the first and foremost is to ask people, to interview a lot of people in the company to see how the person is, what the background is, do a background check, forensic check, how the family is, family background, financial, all of that, how the spend is, how the lifestyle is and all of that. But apart from that, there is a lot of things that come out of the chat engines of a company. So the way people chat and write emails to let's say a female employee or female writing to a male employee gives you a lot of insight into their psyche and the way they write emails and chats, right? So the chat engines internal of the company becomes very important for us if we were to do a sexual harassment investigation case. So that is where again digital forensic comes to play.
Not unclear it is,
It may not be,
but it is just.
but then when you have those kind of leads,
leading evidence.
not always will it be only corroborative, it will be a direct evidence also. So the way he or she has written to a lot of colleagues and then interacted and then asked for a coffee or whatever, the frequency of it, the consistency of it matters. So it is not only capturing data, then you analyze certain things, certain patterns in the behavior of the person. So that gives you a good amount of lead rather than only relying upon interviews and asking people and all of that, because that again becomes a hearsay. Then you have regulatory compliances like SEBI, CCI, RERA, income tax, GST, you name it, and every regulatory body in India right now takes help of digital forensic experts. One, because there's lack of tools and technology available with them. The infrastructure that we have, they don't have that kind of budget to, every 1 year you would have new tool or technology coming into the market which will be better, speedier than the earlier ones. So income tax or GST, when they make a raid anywhere, they would have 2 or 3 people with them to do that digital forensic then and there, so that they can unearth a lot of data, so that those 5 days, 7 days that they are on raid, they can pull out more data. CCI, again, they compare a lot of data, the emails returned, cartelization if there is any, all of that, they investigate big way using digital analysis. And then there are commercial disputes, arbitration matters where obviously the data is read.
So during this digital forensics, do like the company in which you are working, so do you guys need any search warrants or something in particular to do on this digital forensics?
No, our contract is more than sufficient for us to act upon in usual cases. So we rely on certain documents. I'll show you. There's one 65B certificate and there's one consent form. So let's say, okay, I'll just jump onto that because you've asked this. let's say I am called by you, you're a client, you know, taken Tamara on board before us, because usually that is how it happens. You take them and then there's a client attorney privilege also. So when we called upon, we would then rely upon you to give us a consent letter. Okay, now because that is a laptop belonging to your company, so you would say, okay, we are okay for you to go ahead and do this. But if that was the same for a mobile phone, and if the mobile phone particularly belongs to the suspected individual, we or you or the lawyer has no right over it. So if they come ahead and say, okay, I am okay, you can deal it, because he's clean, right? He just doesn't want to hide anything. If he is hiding, then he wouldn't give. That's the straightforward, conclusive thing that you can take up. If he is hiding, he won't give you consent.
But it can amount to breach of privacy.
It won't. If you take a consent, then it won't, right?
So what about in criminal cases where generally these laptops and mobile phones are seized by the police, and then they make a digital forensic on those devices? So then how you proceed in those matters?
So same again, people like us are always contracted or appointed by, let's say in criminal matters, by a prosecutor or someone who is conducting law.
So then who will be appointing and which person will appoint you? That it is police?
So
or
we've been appointed by income tax also, RERA office also, CBI also, SFI also. So those regulatory bodies have the right to appoint us. They have all the rights over the data or the assets that they have seized in their raids. They have all the rights. So they can then appoint us. Even for that matter, a liquidator.
So you are basically an expert that can be called upon by any party.
Exactly.
On a-
Exactly. Yeah, it can be.
Sorry, if I can just jump in there. See, I think that's the difference, and that's something that we also wanted to sort of take you through, and that is that you have two different mechanisms. So your machineries are very separate. So you have one which is, say, an individual opting to get a forensic audit done by a third party. So you have KPMG, you have EY, you have all of the your big four who actually have forensic investigative departments, and that is essentially what they do. Whereas on the other hand, for criminal related activities, you have the state machinery. So under the state machinery also now you have you have separate cyber crime police. So they are also trained forensic investigators. So you have mechanisms in which you can have a reference made to your cyber crimes police, and they will seize the laptops and they themselves will undertake an investigation. So we've actually seen a lot of situations, especially with child pornography, where laptops, if they find, they're actually able to get hold of a laptop, they will investigate the laptop themselves. So if they find themselves unable, if they don't have the tools to do it, that is when they bring in, a third party. So this is actually the crux of the issue even under the Indian Evidence Act. What is the viability of using a private investigative report where you have an individual or a company hiring a third-party private investigator to do a digital analysis of a laptop or a phone, etc., and then present that in court. So over the last couple of years, I think in the last 5 or 6 years, there has been several cases in which, especially including pure criminal offences, where private investigators have been called upon to undertake an analysis, and unfortunately at this point courts are not willing to accept that. They are saying that as long as we have the state machinery, as long as you can go to a cyber crimes police and report your crime and they can investigate it, we are not going to rely on a private report. And while in commercial arbitrations we have commonly seen them relying on private investigative reports, calling on expert witnesses, having the expert witnesses cross-examine for the purpose of ascertaining, what is the viability of that information, how was the report prepared, have you completed, the necessary consent requirements. But in terms of pure crimes, so even under the IT Act, there is actually an adjudicating authority, which is usually your IT secretary, and he has the power to refer a matter for investigation by the cyber police. Cyber police look into the matter, they actually conduct the audit themselves. And as Keval pointed out, the huge issue that they're facing is with Mac products, because almost all software companies, where your confidential information is probably the highest, and that is where they're storing all of their information. Backups are also getting deleted, and with Mac laptops, that's one of the biggest problems that forensic investigators, police investigations are facing, that they're unable to then ascertain that information from a Mac laptop. So while the process that may be followed by both the police and the private investigator are ideally the same, the question of admissibility is what the Supreme Court is also faced with now. And that's why the Supreme Court has actually said, under the IT Act, bring in rules, specific rules for private investigators, bring out forms that they would need to sign, they would have to meet certain qualifications. Unfortunately, so far we don't have those guidelines in place. But they are working towards actually setting up a set of rules where private investigators will have to comply with certain requirements, and once they comply with those requirements, that becomes admissible evidence in court. They can be called upon by courts to give expert evidence. In a recent case that I worked on, I was actually the commissioner. I was appointed as advocate commissioner, and we, through the court, through a commission from court, they brought in PwC to actually sit in court for a couple of days. The laptops were seized, brought to court, and the investigation was actually carried out in front of the judge. Sort of a time-wasting process for the judge because there are a lot of other things to be done. But it's definitely a move towards accepting the fact that you can have a private investigator who can give you the information that you need. And we actually secured a lot of information from the laptops. We were able to see, we actually got a lot of WhatsApp and Telegram chats that had been saved, where they had sort of discussed what are the options for us to take our data, what kind of data would we need if we were to set up a competing entity. And because it was done in court, even through a private investigator, that became hard evidence. It was enough for the grant of an interim order, it was enough to stop them from setting up that business, and eventually it will be enough for them to say that there was a definite intention, even to prove the intention to commit a crime of theft. So for them to then file a criminal complaint, that was enough data. So sometimes a forensic audit also is not just to understand what has been removed, but it gives you a clear indication of intention, so that even if you're not just claiming damages but you're taking criminal action, you get enough material to be able to do that. And that is where digital forensics also becomes so important, because sometimes you know that the employee had the intention but you have no way of proving it, whereas conversations, the nature of transfer of emails, especially during, say, notice period. Someone's on their notice period and transferring, old emails, conversations, client lists. Then, your digital analysis is able to show you the intention of the person. So that gives you a lot to take criminal action as well. So, yes.
Whatever the investigation or the analysis are made by these private investigators, whether their opinion or analysis will come under the section 45 of the expert opinion that is mentioned in the Indian Evidence Act.
So far, unfortunately, it's not being treated as expert evidence. But just 1 second. The move under the Supreme Court rules is that it should fall under expert evidence, because if they're signing off on it, especially if you have people who are trained to do this, to be able to prepare a report and give their opinion, then they should be treated as experts. So in arbitrations, however, they are being treated as experts, called upon to give expert evidence and cross-examined as experts.
What are the conditions which make these evidences more credible and conclusive in nature?
Unfortunately, at present, it's only if you go down the police route. So basically, where you have your cybercrime police
concerned, like we are talking about Mac. Mac does not store the data at all. So for Apple, nobody is going to purchase the product if they are going to store their data.
Correct.
Because as an individual, I want my data to be protected.
Correct.
As an expert, you want my data to be there, somewhere there where you can recover the same data.
Okay, I'll intervene here. So, when you say my data, what is my data?
My data is my
When I am as an investigator pulling out data or extracting data in the first place, that is the data that belongs to the company. Okay? The data is not an individual's data. If you have stored your personal files in that laptop, it is your problem in the first place. That was company's laptop. You used that for personal use. In fact, the company can sue you for that. I would have come up behind you to say that, look, how dare you use my laptop for your personal benefit. I would turn around tables and tell you that. But in the first place, the laptop is belonging to the company. You've stored certain data. Now the data is twofold. One is your personal data, maybe your pictures, your family pictures, whatever, your bank accounts, your personal. And the second is related to company. I am interested in the company data. I am not interested in the personal data.
A case came to me yesterday itself. The person was on a project. He is from Pune-based company. Now the project was of Google. The main person was Google who was handling the project. Now they have transferred the project from this company to another company. Now the person who were working for this project were already mentioned in that project list and all. So the company to whom the project has been submitted, now that company is asking these employees that you can come to us. The laptops are taken away. The laptops and the digital data is with the custody of this company. But still there is too much of
Knowledge transfer.
yes, knowledge transfer that can be done, because when I was in this company, I was gaining each and everything.
So that is outside the purview of digital forensic, right? That is something that you are carrying it in your head. That can happen to anyone.
I can store that in somewhere else because I am having the access, both access, my access and this access, computer access.
Okay, so what is your question? The data got transferred through a device, or the data got transferred in my head and when I joined some other company?
Through my head, through other device.
Exactly. So that is where your employment contracts come into picture. You do not disclose confidential data of a company, but that is outside the purview of digital forensic because you have not transferred anything to a digital device. Now, if I were to investigate your new laptop which has the old data, you will be into trouble because you have that kind of data from the other company unauthorized. Getting it? So until you transfer, employment rules will be into play. The moment you transfer and I investigate that laptop or the device, digital forensics come into play.
Do you guys also develop software to prevent fraud in the first place? So for example, it's very easy to set up a Dropbox, to store data and fix that problem. Secondly, you can also track logs to prevent bulk copy pasting of data and things like that. It's very simple.
So
why don't you guys do that?
So we do that. For bankers, we do early warning signals, which is EWS. For other corporates, we have fraud risk assessments where the IT, I wouldn't say the entire system, but the IT access points, your pen drives and your emails and the sites that you open, the Dropbox, you may, close out all the Googles and the Gmails and Hotmails and Yahoo. But ultimately, even as simple as, you can pass on that file through a LinkedIn chat also. So if the LinkedIn is open, again, you can do that. So there are multiple ways. The moment you, track down and close out 10, the 11th will be open. So it is limited that you can do unless you keep on monitoring it. So to answer your question, yes, we do. We do help people on what is important to them. But at the end of the day, someone who is going to find a loophole, they will. So it is always a continuous monitoring that happens to prevent that.
Now I have a question. Like, can a company get an order from magistrate that they want to go through a private investigator rather than going from a state mechanism? Because state mechanism can take a longer time, and time is the main essence of this whole digital forensics. So can magistrate provide such orders for?
Yes, they can.
when there are essential details of something on the site, like my account numbers and all, when I try to take a screenshot, it says that personal information cannot take a screenshot. But the person, without taking a screenshot, cannot take a videography of
They
the
can.
site.
We've
So-
seen cases where people have used Google Lens and captured everything on.
Yes, whatever it may be. So if such kind of offense, if such kind of transmission takes place, does your this comes into play picture?
Yes, but the way in which it would be unearthed or discovered will be different through a CCTV, or while you are accessing that, someone would have noticed and all of that. It may not be possible through a digital forensic, because in the first place you do not have the device to examine. I should have the device to examine, right? So if I have captured something on a Google Lens, I should have that Google Lens in front of me to evaluate and to examine. So if I don't have that, then people, what they do is they opt for other things like going to a CCTV or accessing records or accessing logs onto a computer, which screen, which part, who is accessed at what time, and so on and so forth.
When we were saying about employment stealing the data, employment theft data, so this can be easily done. Like when I am online doing my work, I can keep a camera and all, and I can just keep the track of whatever we are working over here. I can create a record of my own whatever work I have done, whatever difficulties I have seen, and whatever the team has taken into consideration and done something. I can create a different record of the same.
Correct, but
Without-
finding that out, see, now suppose you do stores, suppose now say with someone who's in sales and marketing, they know all the clients of the company, that's in their head, they know who they're dealing with on a daily basis, then I can't stop that. But the problem arises when they reach out to that person and say, oh, now I've started this company, this is what I do. More often than not, a client is going to come back to you if they are your regular customers and say, look, this person, I was dealing with him at your company, now I'm dealing with him. He suddenly come to me and says, he has the same expertise in a different setup. So all of the data, then we know you recorded that data, you're using that data. We take steps based on that.
But it depends when the person who has been lured into my company, that now I have a separate entity, you can come to me.
Which is not wrong. Which is not wrong, right? I mean, as a professional, if I tomorrow, okay, so Tamara or myself, if we tomorrow, leave this company and join some other company, bringing in a client after a certain period is over is not wrong, unless I'm using that confidential information to get to the client and tell them that I know something.
And
Unless-
then you ascertain the information, then we know what you're doing. And that's when the investigation begins. Essentially what you are talking about is the theft itself. But where do we come in is when the company realizes that the theft has happened. So the theft can be happening over many years. See, there's no way of us essentially preventing that in advance. It's only when you get a hint of what's going on that you take the step. So and that's why contracts have clauses that say
Just
you
a
cannot-
trigger that where you misuse that information that you have. That's about it. The moment someone realizes that you have misused, they would come behind you.
Ma'am, when a private entity comes into the picture while doing a forensic investigation of a person's data, so what are some protections given to the person which data has to be investigated, and what are some liabilities to the public entities when they have to do forensic investigation if they misuse the data?
Okay, so with public entities, as long as they've got the consent form signed, then there's very little in terms of, they're not supposed to leak sensitive personal information, of course, but we don't currently have enough data privacy regulations to prevent, while you're not supposed to leak the information, that's about it as of now. With a private entity, I think there's a higher obligation cast on them to keep the data in a particular way. So when you're storing the data yourself, you're not storing bank accounts, you're redacting bank accounts or whatever other information. But on the other hand, what one has to also take into account is that if you have, like Keval mentioned earlier, if you've kept private information on a company laptop, then you are responsible for putting that out there. Because what I'm looking for is what you've done during the term of your employment. If you put additional information that you treat as sensitive personal information, and I find that I'm under no obligation to
perspective, while there is no like privacy laws and all as robust as you want, there is always a non-disclosure agreement that gets signed with someone like us, right? I also have a separate NDA than my normal contract. The NDA is a good 4 or 5 pager. I don't know what all clauses lawyers put in, but it protects your data any which ways. Every access that I have to the system or the laptops or the devices, the data is protected so that I cannot misuse that, I cannot disclose that. Now it encompasses everything. It doesn't bifurcate into personal and company data. Any data that I am accessing is protected.
Sir, regarding the earlier portion of collecting data from the Mac laptop, is there any mechanism through which the companies can, like the companies in which you are investigating, can directly contact the manufacturer of that?
So it doesn't happen with a Mac like manufacturer. They won't do that because they also do not have the data. It is wiped off, means it's wiped off. There are government authorities who have the right to access a Gmail. They would write to a Google, to have access. People oblige, sometimes they do not, sometimes they take time, sometimes they don't. So it depends on, so like if as a company you are going to go that, I have found out XYZ particular employee has taken out data and that Gmail has it and all, Google is not going to oblige. If a government authority writes, they will. So it depends. I mean, but not from a device point of view. You're not getting anything from a Apple software. It might be because they have the cloud storage anyways.
So I think we've covered the admissibility part. I think even chain of custody somehow in the discussion, I think we have covered it to some extent. But what I think it's important to understand is when we talk about chain of custody, what we're essentially talking about is how is the movement, not just of the data, but the machine itself. Suppose you're dealing with a laptop or in courts, when we seize a laptop or even if it has to be investigated, you have a particular way in which it's done. So so every investigation starts off with them giving you a masking tape and a color or 2 sets of colored pens. So the way the chain of custody moves when you do a court investigation, and this is very important because your Evidence Act does not tell you that this is how you do it. So you basically put an X mark across the laptop with the tape and then you sign on it. So the advocate commissioner or the person who is charged with investigating that laptop will sign. And that is because we don't have a consent form in court. Once you're appointed, you become an expert witness by default. So these are sort of steps that have procedurally been formulated so that that chain of custody is shown. And then you put it in an envelope, seal the envelope, present that in court. So that sort of takes care of the chain of custody of the machine itself. And then with the data on the laptops itself, you have the same sort of consent form, and we will show you a typical consent form where the person is basically saying that they are amenable to you going into the data on that laptop and understanding what is there and what is not. Now with company-related laptops, it's a lot easier because the company also has to give consent, but especially if they've already gone into litigation, the company is obviously okay with you going into the laptop. The larger issue is with cell phones because most people don't have a separate work phone and a personal phone. So people are not keen on giving their phones because of, there's also personal data, personal information, some of which may be, sort of damning against them, and some of which may not be. And sadly, at present, we don't have a system in which, whatever information, there are no rights against self-incrimination of data that you find on these laptops and phones. And that's one of the larger issues that courts are also facing, because if someone's giving you consent because they don't know how much of information you can access. And in evidence, we've actually seen when using a forensics report. But with respect to a private arbitration, especially if it's a client hiring a private company to do the investigation, then it's a simple contractual arrangement. Chain of custody is based solely on a form and a non-disclosure agreement by both parties. Whereas, of course, in recent times, we've actually seen a lot of situations in which they want the lawyers to hire the agency as well, so that everyone's bound by the attorney-client privilege. Hopefully that will be seen, if everyone's under the same privilege, then arbitrators will also be more keen to rely on, that sort of expert evidence, and the chain of custody will be clear. Like I said, while we don't have it strictly under the law as yet, hopefully, in the coming months, we might actually have robust regulations on what the chain of custody should be for forensic analysis. I think this maybe largely, if you guys want to have a look at the judgments and see why the courts are taking these views, they have expressed some sort of opinion. It's a very long judgment, so I won't go too much into it. But that's why they've now also set up a committee who can, look into what the regulations should be, what they should include, and how we can start to rely on digital forensics. I think we've largely covered this also through the discussion. So if anyone has questions on any of these things, yes.
So let's say there's a situation, a person is working in a company, he has a company's laptop, and he has his individual laptop, private laptop, out of his own use. So let's say there has to be a forensic investigation by a private entity. They have gone through the data of a company's laptop, and now they have to see in his private laptop. So does going through the private laptop of the individual comes under the jurisdiction of private entity to do forensic investigation, and if it does, isn't it a breach of my right to privacy? A person's right to privacy?
He can refuse. For a private laptop, he can refuse. A private phone, he can refuse. In which case, they'll have to get a court order. Direct him to provide the laptop for the purpose of investigation. He's not under obligation to give a private laptop.
Even if he has stored some company's data into his private.
Even if he has. I mean, we'd have no way of knowing that, but in order to ascertain that, it'd have to be through a court order.
And what are the practical difficulties these forensic experts face while dealing with the white-collar crimes, which are generally cross-border in its application? What sort of practical?
Cross-border will largely, most times, come down to an arbitration. It's very unlikely that you have a cross-border transaction which would have a clause in which it would go to a court of a particular country. So, and that's my experience at least. Most cases it's an arbitration, and in arbitration it's a lot easier because there's a lot of, it's more of a private setup. So being able to access the information is more between the parties. It's a smaller sort of, you have a shorter timeline, you have easier access to the arbitrator itself to explain why you need the data. Does it mean that it's not possible data will get deleted? No, because once the arbitration commences itself, you can have a lot of deletion of data. But cross-border transactions, being in arbitration, it's easier to access the information. That's for sure.
And we've seen people, tribunals also onboarding forensic experts to do that kind of analysis and come back to them with a report. To the earlier question, in my experience in the last 4-5 years, I've had multiple cases where we've gone to judges. Very recently, Kathawala also, where we've seen certain traces where someone would have taken away data, and we had some kind of speculation based on certain evidences found. So we got the order immediately, and we had to take the laptop. So we did that. But you, as Tamara said, you need to have a court order to do that. But it is not that challenging. If you have the right kind of evidence to show it to the court, they will give you. If you've done something wrong, if someone is attacking you, where is your privacy coming into picture? You've breached the entire confidentiality thing by doing that in the first place. So the court is not going to look at that because the court relies on certain evidences shown to them. Okay, so what then in that case, to counter your question, what happens in a case where a court gives right to conduct a raid or enter house premises to see where the black money is lying? I mean that is the maximum level of privacy breach that can ever happen, right? Entering your house.
But investigation should be treated with fundamental rights.
There is also a restriction of the right. If you go by Article 21,
As long as it's reasonable. As long as, see, if you have reasonable information to say that this person has stored this data or transferred this data to this particular laptop, that is what the court is relying on.
Then you cannot.
So,
Was in that case, any kind of black money that you store in your bank account, you would say this is my personal account, boss. That does not work that way, right? You can have your personal rights to a limit.
Is that the right to life can be curtailed by a procedure established by law.
correct.
Exactly.
And that's why we say you have to go to court. Because a private investigator cannot come and force you to give up your laptop, your personal laptop. Whereas the court is that way empowered to ask you to do something when they reasonably believe that you're violating the law or breaching a contract or whatever it is.
Recently you said that the lawyers are also hiring private investigators to conduct the investigation. Now, are there any instances where what investigation is done by a private investigator and what investigation is done by a government investigator, and the opinion of both the investigators are contradictory? So, are there any instances, and if they are, what which will prevail and what the court will do?
Okay, so recently we did an investigation where we did the primary investigation through a private agency. That was because we had an inkling of what was going on and we wanted to know more about it. Basis that, we filed a civil suit, got an interim order, and got all of their personal laptops, phones, and everything as part of that investigation. We then handed over all of those laptops to the cybercrime department to investigate, and we used that to file a criminal complaint because unfortunately the magistrate was not willing to accept the report of the private forensic investigator. So I don't think there was a conflict in terms of what information they secured. The information was the same. Of course, because they got the private mobiles, they were obviously able to extract more information. So from there we got WhatsApp conversations, a Telegram group that had been set up to say, this is the name of the company, this is where we will take premises on lease and everything. So that sort of tied into the entire suspicion that we had when we did the private investigation. So what I would say is that going through the government agency gave us more information. So there was no conflict. Did they take a little longer? Yes, because they first needed to do the primary investigation of actually going to these people, speaking to them, and then going to the cyber police. So I haven't seen a situation in which there's been a conflict, but I think that government agencies are able to extract more.
Just like this news student, there is a case of white collar crime, and mostly in the white collar crime, the influential persons are involved. And just if we go to the government agency, they have those capability to influence those investigation. And if there is an instance that they are influencing those investigators to give an analysis in their favor, and as being a lawyer or being a private investigator, that you know that whatever analysis given by the government agency is not appropriate, then in that circumstances what we can do or what we have to do.
Once again, the option is to go to court and ask for the appointment of a private investigator. That is always an option. But of course, you'll have to give the reason why. Now, suspicion of a government authority is not a tenable option. But if you have reasonable proof that there is something more to it, or a reason why you believe that this is the case, then it's possible to get a private investigator.
It is necessary for the court to look at upon the prima facie whether the case is
Yes,
tenable or not.
yes, absolutely. Because very often you will want the appointment without notice to the other party. So if you want an ex parte,
Based on how much we can convince the court.
yes. How much of at least prima facie material that you have available to get the investigation.
So, is there a mechanism in place for certifying these private investigators in
There's no mechanism, but there are certificates and degrees that people have. So
and it is same for both public and
So private agencies, you may not have someone like, okay, for example, people like us, maybe a certified fraud examiner. Okay, I'll have my team members who are experts in digital forensics. They would know in and out about hacking, all that thing that goes on in the computer world. The investigation agencies like SFIO or CBI, they will have their own kind of expertise. They may not be technical experts. Some of them may be, the younger lot may be, or maybe one or two team members they may have to rely upon, but they may not have all the team members on this. They may be an IAS, IPS, whatever. So to answer your question, there is no accreditation that is required. It can be from experience also, but there are certain degrees and certifications in the world, like ACFE is the best one for certified fraud examiner, that is globally regarded as the best one. But other than that, on digital forensics, there will be certain courses that you can do. Like Gujarat has a good university on forensics, so they do have a long-term course also on digital forensics.
Sir, can an employee hire you for getting an overview of the digital forensics which has been already done by the company, so that if there is any manipulation, there can be a conflict in digital forensics?
It can be a counteract or a preventive kind of thing where the employee thinks that something may happen.
Create a doubt in front of the court of law. Because then
If the parties are entangled in a dispute, then yes, probably the employee will then do that to prove it to the court that look, I've hired a forensic guy, he's saying XYZ, which is countering your, the other party's opinion. So the court has to then decide. But to answer your question on the other thing, there is difference on the investigators. I'll just make it quick. Tamara already answered that. So in the case, the large case that she mentioned during the introduction, so the biggest, the banking fraud. So we had a limited scope. So we had around 18,000 odd bank accounts or something, okay, to look at. Similarly high volumes of laptops and emails and everything. However, we were bound by the scope, number of years, number of people, everything. When the case then went to CBI and SFIO, they called us and they said, okay, boss, you've left out these many people who were in that role in the bank previously. So the bank used to change people every 2 years. Okay, so we had reviewed the emails of the last person who had given access knowingly for only 2 years of email. Only of one person, the designation being the same, but the previous 8 years we hadn't seen because it was not a part of scope and they did not have the right to do that. When it came to SFIO, boss, everything is within their purview, they can't be stopped any which ways. So they told bank, boss, give it to them, you search whatever server you want to. Right from the initiating years, they gave all the data, which was like 5 times the data we had reviewed. So when it comes to private investigators and government authorities, they have more rights to do it and more powers to do it. Big cover thing of us. I just want to see. So this is how a chain of custody document would look like typically. So you would mention, the time and address and everything that is collected, evidence that is collected, okay, right, every detail of it, manufacturer, serial number and all. Images, image details. So we'll go about it in the coming slides. So once you have access to a particular device, you typically do not act upon the same device. You first create a copy of it and then evaluate that. So these are the image details that are taken. Any remarks that the investigator wants to put here? Again the same, the chain of custody. So every time the device or the image changes hands, it's like a handover takeover kind of thing, so that the entire chain is maintained, who's given to whom. It's a simplistic format. I mean, people may have their own versions of this also. Yeah, Again, there's similar what Tamara had mentioned, the evidence team, 65B. So I'll quickly go to this one. This covers both user and expert. Is this legible?
Yes.
So this simply says, like, if I am an employee of a company, okay, I am an account holder of these XYZ emails. The information contained in the above web email IDs were fed, being received on ordinary course, blah blah blah, into my domain and control. Above mentioned email accounts were functioning properly, no such operational problem. So all of this is to protect the report and the findings later on, because someone cannot then go and question that I was not accessing, this is not operational at all, I do not know who from IT did that, all of that blah blah. So this is abundant precaution that one needs to take. And also similar things are for the investigator also. For example, here that I have taken so and so, see this, with reference to assistance to Enforcement Directorate Zone so and so. During the course of such proceedings, I received credentials of below mentioned email IDs from so and so for downloading complete email backup. The accounts were logged in with given passwords in the presence of the user. So then someone may not even challenge के hack करके किया, and then you have all the details of the email IDs and your hash totals and all of that. So it's more like a consenting that people are giving you all the details, which is bona fide enough to proceed. This I think we spoke, right? Yeah, we can all the things that we can digitally analyze and yeah. So this, which I was mentioning earlier, these are some of the tools and technologies that we use typically for digital forensics. There can be much more than this globally. Out of these, like for example, if you were to ask me, Intella, Nuix, relativities are something that we use very often on laptops. Relativity is globally renowned for its arbitration matters because of the data integrity that it maintains throughout. UFED, if you see here 22, this is most often used for mobile forensics. So likewise, you would have multiple softwares. Some may be for laptops, some may be for mobiles, some may be for imaging and processing, some may be for only reviewing. So it depends on what is the use actually. Now, next 2-3 slides are a bit technical. I mean, out of my domain also in a way, but still we'll make an attempt. So these are the 4 basic steps. Okay. First is the acquisition of the device. Second is recovery of data. Third is analysis of data, and then is the presentation. Okay. Now in acquisition, the goal is to recover as much evidence without altering the crime scene. Investigators should document as much as possible, maintain chain of custody, copies of evidence, is there a warrant needed, shut down or keep operating system. So shut down and keep operating is one thing where you need to take a call. So for example, if there is a server that needs to be processed and evaluated, now there is a very high chance that the company is doing really good. You don't want to hamper their business operations. So then you need to take a call, because if you are going to continue with it, and then if the allegation or the nuisance is such that it will create more problems by continuing, then you will have to take a call and to tell the management that look, these are the 5, 6, 10 hours that we require you to shut it. Whatever operationally or whatever, if there is a separate financial software that is going on, you want to do that, run that. If there is a separate operational program running or the ERP where you would want to record the production, the purchase and everything on time, you don't have to take a call. Recovery, so I have a separate slide on recovery. Okay. So recovery of data is the most crucial before you even start analyzing and all. So file systems where you have all files, directories, meta systems. I don't know how much as a layman we all understand metadata and all of that. For me, I don't personally understand a lot of it, but these are, I would say, smaller things in the computer or in the device that leaves a trail, the audit trail, through which you may not see the entire file, but you can always get the file produced again. Cache memories, everything, artifacts, your timestamps, your login details, everything. Some deleted files may be recovered, slack space. Deleted files, we've seen in my experience 80% of time we are able to recover, unless there is something like a Mac. I don't know how to crack that sometimes, but usually we are able to crack it open, because not a lot of clients in India give employees a Mac, so we are safeguarded in that sense. But unless it is overwritten, a lot of times you can fetch the deleted files also, and there are softwares which can give you that kind of deleted file. So when you are imaging, okay, there is a process of indexing and all. So when you are copying the entire laptop hard disk into a new hard disk, there is a certain step to be done which covers your deleted data also, hidden data also, and then when you analyze that, you can see all those data. But the imaging has to be very robust on all that you have to copy. File deletion we spoke. Encrypted data. Now depending on the encryption method, it might not be feasible to get the information. Locating the keys is often a better approach. A suspect may be compelled to reveal the keys also. Sometimes if the employee has a suspicion, we have seen that they have absconded. Okay. Now the password then they leave it to us to crack it, or their IT guy, sometimes they find it easy from the admin login IDs that they have admin right superseding the normal account. So in those cases it is easier, but again then the chain of custody plays a very important role, where you have to say that look, we've taken this access from the IT guy, he's opened it up, or if I'm bringing up a new guy altogether to just crack the password, and then my other guys, team member is going to review that. There are different people accessing the same device, so again you have to be very, very cautious of how do you maintain the chain of custody. How do you tell the code that the data was not tampered, it was only to do this. And then file residue, as you said, web cache and all of that, so that gives you a trace on what websites were accessed, what files were accessed, what images were accessed, and so on and so forth. And then the analysis, again there is a different set of rules. Contraband materials, locating materials, needle, haystack, authorized. Everything that you access in a device is something where you would want to channelize things where it will be easier for you to review. So once you extract data, it is not only that you've gathered data in so and so format, but it is always helpful to process it. So that is why we image and then we process data. So that's the step is known as processing. Now that processing, what it does is indexing and processing. Imagine this, the entire data of a laptop getting into an index form. Okay, you can just click and access, because the data in the laptop may be arranged in a way how the employee or the person has arranged. Now you want certain objective to be fulfilled to access and review it. So for you it can be, let's say for example this was a kickback case. Okay, the employee has entered into a contract with the vendor, onboarded a vendor, and then getting kickbacks from the contract that they have. Okay, so the company is paying 10 lakhs a month to the vendor, 1 lakh is coming back to the employee for getting him on board. Now in those scenarios, there are certain, so we'll come to one slide later on where I've mentioned certain kickback keywords. So there are keywords which will help you to identify which data, what to see and how to see. So for example, there is also collation of data happens like a folder wise, subset wise. So the indexing and processing arranges the data in such a way that you can easily analyze things, rather than just opening up folder, each and every folder. I mean there will be 10, 15 layers of folders, and then you'll find nothing relevant for you, right? Again you go back and enter a folder. So how indexing and processing helps is only to collate in a way or to arrange in a way where it is easier for you to access and review.
Sir, while analyzing such voluminous data, there is always a good chance that due to some human error, some of the relevant data which would actually overturn the entire case, it can either
miss
go
out.
unnoticed.
Yes.
So sir, what is the mechanism to, is there any softwares or other technological things
So
which
one, as I said, the keyword searches help. Indexing and processing is only just arranging. So when you start reviewing, the first thing we do is the entire team sits for a couple of days, not even couple of around 2 to 3 days, just to identify those 200, 300, in some cases 500 keywords. Now this is just an example of, I don't know how many, 50, 60 keywords or maybe 70 keywords. Depending on the project and the case, you would have to arrange the keywords. You have to maintain a combination of keywords. For example, let's say employee and kickback. If the employee is using certain words and phrases, you make that as a phrase. If that vendor is a keyword, you want to search out every file along with that vendor name is a keyword. So you draw out those keywords. There will be 5% chance where you have not covered that important email or a file which is there in the device, but due to your keyword limitation or you've not thought of it, maybe you miss out. One is the keyword, the first attack for us. The second, how every investigating team works is, there will be a team who will be reviewing this data based on the keyword searches every day. There will be a supervisor to it, to every team member. So 10-20% is the sample that we keep, that we've reviewed more than what the team member would have done. That's the second check. But to be honest, to answer a question, there is no technical device frame to not miss out on these things, because this is again a chance that you're taking, and through a structured way, because otherwise there'll be like thousands of files and lakhs of emails to review in a span of, let's say, 8 to 10 days. I don't think Tamara and lawyers would give us more than that, but to do that in that span, even if one team member sits on one particular email ID, it will still take you 7 to 8 days only to review on a sample basis through keywords. Because you don't just have to read the email, then you have to follow that email chain trail, and then to corroborate that with your file details and laptop details. So if I find something in an email, I then need to see whether this was done on that day or not. Then I have to jump emails also. So it is not just reading 100 emails a day. That 100 emails, and then plus to understand the entire story behind that email also. So very right in your question, but there is no right way to do it. It is only the best way how you can manage and what you can think of. So the more you understand the case, the better the keywords are.
Sir, there will be many instances where the data which you have restored are beyond your expertise, just like they are into more finances. Then how do you analyze those data which are not comes under your expertise?
So forensic investigators would typically have a forensic accountant also. It is not only the IT guys. IT guys and the IT team members help ends until the processing of the data is done, imaging and processing. The review part is with someone who understands the subject. So for me, I am a chartered accountant. I am not a technical guy. So my team would do it, but I would then review it. So people like us would review who would know the subject matter. So if the matter is about, siphoning of funds, or maybe rerouting of funds, or layering, or maybe misappropriation of assets, or playing around with the financial books of accounts, passing entry, and all of that, that is something that we would know by reading the books of accounts. But if I tell my IT guy to do that, I'll be in a mess.
So the step of analysis will include these subject experts.
Absolutely, they will have to. I can't ask my engineer to read a financial statement, right?
Basically, the analysis part is more of the subject expert.
Subject expert. It can be anyone. It can be an engineering expert also, accountant also, or anyone. And then the last one is the presentation. As they have to present in the court of law, and how it helps being an expert witness also. It is not only about just putting across your thoughts, but it has to have a story behind it, reasoning, strong evidences, hard evidences that you have noticed in the digital forensic. Because this is one area along with document review which gives you hard evidence. your market intelligence, your asset tracing, your conducting interviews, everything is just hearsay or corroborative, whatever you can gather. But these are areas of investigations which give you hard evidence, and that is where you need to present your report in such a way that there is no question asked whether have you covered this or this. So the way an investigation report is drafted, it gives you a story on how did you start, what was the data, what were your steps, what were the precautions taken, what have you used as a tool and technology, and then what is your conclusion. So it encompasses everything.
Do we have any rules and regulations, standards, which is made by government, which say there are certain standards to analyze, recover, analysis, and whatever this entire thing is, entire procedure? Do we have certain standards set by rules and regulations made by government?
If your question is around digital forensics only, no. There is an ISO standard, there are multiple ISO standards, but those are covering everything. So they cover forensics as a branch, okay, as a study. So for them, forensic is not only digital forensic or white collar crime. For them, it is the scientific, the medical, everything, the criminal part, the murder, everything. So that is ISO part. There are no international standards on digital forensic. However, once you start analyzing or reviewing the data, if I were to do that, I would then say to the court, for this particular country, we have accounting standards, for example, valuation standards, for example, XYZ standards on different counts. So if they are, the data or the things are not in alignment with these standards, it is wrong in front of me. So for me to do my work, there is no standard, but my output definitely has a guideline to fall back on. Did I answer your question?
Yes.
Sir.
If I may add, for cybercrime investigations, police have standard operating procedures, but they don't make it public. It's not in public domain. But for the cybercrime investigators, that is a state procedure. When it comes for private we don't.
Sir, when it comes to methodology, how are we compared to US? Like they might have their own methodology of working in this digital forensic.
Not really. So the tools that I showed you, these are 90-95% from outside. Very rarely you would have an Indian. So the tools and technology would give you the same result. It's only after they get the data, they would analyze in a particular way because the case is so, or their internal standards are so. So for example, their IFRS reporting will be different than an Indian accounting standard. So which may,
The base is same.
sorry?
You are saying the base is same.
The base is same. In fact, you would be surprised. So US is one good country to have these kind of things, but so is Israel. If you look at Israel's forensic experts, they are way better than most of the countries. I think we've spoken on this banking wala case study. Before, I think, yeah, we get on to Tamara's case law. Just 1-2 minutes that I'll take on this case law is one of my favorites also. So this was, I think, 3-4 years back, case study where for a discount company in south of India, we were appointed by a law firm, a leading law firm. The case started where one of the employees or ex-employees had raised a PIL and against a company who was supplying materials from Bombay, and the discount company was in south. So to get the project, the company would have bribed the officials and got the project in south of India. Now the allegations were against a good top level management guy, a sales head basically of the company, to say that look, he's given bribe to get the project done. So the company reached out to the law firm and law firm reached out to us. Now while they wanted to unearth all the truth, but they knew that the more it comes out, they will be in trouble. Okay, so this would have gone for so much longer period that people who are doing this there were multiple people. So we'd got around 10 emails and 11 laptops or something like that, which we had to review. Now they had gone so ahead that, you know, how we chat over WhatsApp, you know, on a regular basis with a very, very close friend or a family member, they would chat likewise over emails. Okay. So everything that they had done, they were so naive, or they were so overconfident that, you know, nothing is going to happen because they were doing it from past so long. So to bid for a project in India, you would typically have an earnest money deposit, EMD as we call it. Now that company was big enough, so they could pay, but they wanted two more competitors who they would want to beat in the bid, right? So they, you know, overnight they had two distributors of them pitching it as a competitor to them. The earnest money was not something that these guys would afford. They sponsored their earnest money to pay to the government. After that, they got it back. So over emails, they are, you know, reconciling things. They're presenting a table where they've said, okay, we have received earnest money. This is the you deduct it from our commission and brokerage every month, so and so. After that, they rigged the bid. So they had certain specifications mentioned out in the bid. That got rigged. The government, you know, obliged to it. They changed the RFQ document. They won. After they won, they implemented the project. They made a government official fly to Sweden on some premise of getting the technical qualities being okayed and verified. So entire family was sponsored. The family's euro currency was also sponsored by the company to say that you can collect it from so and so office at so and so location. So everything, every step that we thought of was so very well documented that we did not have to go into anything else. It was a quick, you know, we asked for some 10-12 days and we got it done in 5-6 days and given a draft report on 2 people. And we said, while, you know, you can, you know, go ahead with these 2 cases, we'll complete the other things. So sometimes people are very overconfident, so naive that they would, you know, mention each and everything that they want to do. In certain cases, we've seen people have their property details, new buy, you know, if they've bought some land, property, house, car, everything, they want to preserve a copy of it. They want to preserve their bank statement because they would have downloaded. So the bank statement will always be on the laptop of the company. In the bank statements, again, then you will find, you know, certain kickback direct deposits happening. Now, if the employee is in, you know, Bombay or Delhi or whatever place, and you have certain bank deposit, you know, coming in from Nagpur or somewhere else, direct deposit. Now, he is not going to travel to Nagpur to get that money, right? So definitely someone else is. So when you then dig out which you can request a bank, because not always in the bank statement you would have all the details of the account number and all from where it is come. But you do certain things, it can be easily found out. And nowadays, through GPay and UPI, you always have that mobile number also coming in a bank statement, you know, transaction detail. So you can always go to a Truecaller and to say that, look, who's this? So you can always do that. So a lot of things do come out of the digital forensics, and this in particular was one such case where it was, you know, 3-day job for us basically, but then we had to continue for the other cases also.
Sir, the earlier case which you discussed of bid rigging, so who has hired you? Like the CCI has given you that?
No, this was the company. The company had because their employee was.
That was the bid rigging of the anti-competitive practice.
So bid rigging is not only investigated by CCI. I mean, it is a crime in itself, right? So the company had hired us to see that their employee had played around or not, any malpractice happened or not, to win the project in the first place. So
Because if it's found out later, they can get blacklisted. So a company would rather know.
Correct.
Then they terminate. They terminate the employee if the employee has been impeached.
And the employee did this because they wanted to know how big trouble they are into because of their one employee. So their one employee would have done this to get the project. He is the sales head now. To get a project and to get bigger contracts is his KPI, right? So the more he does, better for him. So to show that good, he did this, and that now the company would face repercussions. So the company hired us to see whether in the first place this gentleman had done it or not.
I think since we're short on time, we will not go through all the judgments. I think you guys can read through them, but essentially we have covered what the judgments talk about and why they're not keen on private investigators at this point. But you guys can sort of read the judgments whenever you have time.
Yeah. Any questions, any doubts?
I have an off-grid question if you would like to answer this.
Please.
Like in the case of Nirav Modi, it was a glitch in the PNB track software. So how would you proceed in such a case, and how would you get to know who is behind, which face is behind this glitch, or how the whole scam has been done?
There was no glitch in the software. You can read this extensive system integration. So their systems were not integrated. So the software, there is a common banking software that happens on a daily basis. You need to update that on all the transactions. That was not linked to their other businesses or the other locations. So due to which what happened, people exploited that, and they used to record this entry here showing the bank that the loan is taken. But that entry was not reflected in all the systems elsewhere. So evergreening used to happen. So there was no glitch in the system. It was just a matter of integration was not there. So if there are 3-4 different softwares with the bank, everyone has to talk to everyone. So if you've taken a loan from, let's say, I'll give you a very different analogy. If you've taken a loan from, let's say, Powai branch or someone, now the other branch has to know, right, with your limitation and with your banking credits, you can get XYZ loan only. If you go to a Kandivali or a Mulund branch to get another loan on the same day, now they should know that you approached other branch as well. Very similar, not exactly the same, but very similar thing happened there, because people put it on a software which is the global one for them, but they did not disclose it elsewhere. So that is why they faced the problem. So there was no glitch in the system basically.
Can we like take someone who can be held responsible for this thing, or it was just
For this particular thing, no, because the bank at the management level had to take a call on the integration. It's a bank-wide software that needs to be not only in India, they have branches outside of India also. So that's a management call. But if someone at their level has played a gimmick or negligent, then you can. For example, if you sitting on a position and you giving access of your email and your login ID password to your colleague, and the colleague does that, so even you are at fault in the first place. So that is where you can tell someone is negligent or has overseen certain things. But otherwise, this one is at a management level. So they did not integrate with non-integrate.
Sir, many times when you conduct investigations, and so many times the peoples may have challenged those investigations in the court of law. So what are the journal allegations that are made against you, and on what basis they challenge your investigation?
I think data comprehensive is one that they would come up with. That's the easiest for them. They would say there was also this that you did not look into, there was also this. Chain of custody very rarely, because you would follow the entire procedure, you would have signatures, so people can't go back on that. But I think comprehensiveness is something that we face very often.
So is there any particular case in which you have faced the most difficulty?
Not really. So sometimes in cases, in investigation cases, you don't have people challenging from the other side like an expert. In arbitration matters where I do, you have another expert also sitting. So for example, if it's a valuation of a company, let's say I've given a 200 crore valuation, the other person may have given a 300. So then we fight it out between ourselves on technical grounds, why so and so, why so. But in investigations, typically there is no counter attack from other side as an expert. the lawyer or the prosecutor may question, but those are not technical questions then. So if you are a law student or a lawyer, you are not going to question me technically. That is also a benefit for someone like us sometimes.
So are there any risk factors which you have to consider while conducting those investigations?
Many. I mean, your reputation is at stake big time. If you are going to, so most of the times, as Tamara said, people like us get appointed by a company. I mean, though the contract is there, but we can't be telling them that look, we will be supporting you. It is not how it works. Indirectly, you are always reporting to the court or the tribunal because your report is true in every sense. So whatever is, we call it very safely, we call it fact-finding exercise. So whatever is the fact, we have to just report it. I mean, you can't then play around. So even if a client has appointed me, if I were to do certain benefit to him by hiding something or by manipulating, then it may fall back very heavily on me. So the stakes are really high. So you need to be abundantly cautioned to see to it that you followed the procedure to the T. Otherwise, you'll be taken for a ride, big time.
I think avoiding bias in analysis is the most important thing. So basically, you're only seeing what you see. You're not giving, neither are you giving an option of what can be done or can't be done. It has to end at this is what is available. That's the most important thing.
Is to present what they have analyzed and not to give any other opinion other than the analysis.
Correct.
Exactly.
Absolutely. Otherwise, then your report is biased. So there is in arbitration typically there is a difference. In investigation also there is a difference between a consultant and an expert. So the consultant can be in support of you as client. You can support and you can give a good advice. So it's more like advising what is best for you. But as an expert, then you are obliged with your principles or whatever to be in the true sense and true spirit.
So, but still some level of bias will be there, like in the language of your report, you will not directly blame the client. There's some level of bias.
No, it depends on the scope. Again, so the bid rigging case that I said, even if the company was appointing me to see that its own employee had done wrong or not, my report said he had done. My report never said he did not, because they wanted to find out the truth so that they can then strategize sitting with the lawyer on how best we can defend ourselves. Because unless they find out the truth, the other side is going to take benefit of it if they know the truth. So the quicker and the comprehensively that the company knows the truth about it, it is better for them. So it is not always that my true report will give them negative things. So it can be a good way also in the first place. And secondly, if my scope reads that as digitally or forensically analyze certain things or laptop or email of so and so, and these are the allegations or suspicions, okay, 10, 15, whatever it is. So all my efforts will be around that. So whether positive or negative, if I get something or I do not get something, I'll have to mention it in the report any which ways. But I can't hide anything, because then again, when that is audited, I'll be screwed up big time.
I have a question. When such cases come to a court of law, what do as a practitioner of law, what all say check marks you take while questioning, challenging these reports by the experts? From purely law perspective, what all are the major things which we also as lawyers should do while analyzing, examining these reports?
thank you so much. I think this is a great interactive one. Thank you so much for having us.
Thank you for shedding light on such an important topic by discussing e-discovery procedures under civil and criminal laws, technical aspects and tools of digital forensics, problems faced in carrying out investigations, and your valuable insights. I hope everyone has added on to their knowledge through this discussion, and the students have also learnt about a new career option that they would consider to explore. I request Dr. Anand Rao to deliver a thank you note.
Thank you, Amrisha. I missed out in the middle because I had to go for a lecture, but then what I could catch by the end and what I could catch in the beginning of the lecture, many of the terms that he discussed today, I can tell you that each and every term, if you get into it, you know, asset valuation or something like that, it's a lot of things that you have, a lot of efforts you have to put in. But making this complex technical topic so easy to understand, and very categorically, I've been seeing very categorically both of them they put, and as far as making simple, they have done that. You know, this topic can be discussed with lot of jargons which might impress the audience that this is something else going on, but it's very difficult to explain these things in a simpleton terms and terminologies and meaning. So on that front, I think I'm so happy to have invited both of them, and they have been generous. I am very much thankful to Kevin that when we proposed this idea, he was up for it. He said yes, and I said that we cannot, you know, we should not be delaying this thing. If we have to do, we should do it early. He was there. He said yes. And special thanks to Tamara because she flew from Bangalore here just for this lecture, and great session. I hope that all of you have benefited out of this, and as things are going all digital forensics is going to play a huge role in admissibility of evidence, which will affect administration of justice also. So on that note, I hope that both of you would be visiting us and you become a part of the university in some of the other role that I would be discussing with you. But at the outset, I want to thank our Honorable Vice Chancellor and Registrar Sir for providing us all the logistics and guiding us when we were organizing this. They provided us all the support. I also thank the technical staff, Manohar, who set this up, student volunteers Akash and Kinza and Vedant, and other students who were involved in this. I consider Amarsha and Astha as a part of organizing team. So myself, Garima ma'am, all of us, we were part of organizing team, and most importantly, you all. So thank you for being here, and I hope they asked good questions and they were interactive. This is how you should be in other programs also, and also in class, right? So on that front, they are good students otherwise. So
I think we had a great time in the session as well.
yeah. So on that note, thank you. Okay. Hope you have signed your attendance sheet.
Yes.